question that usually comes up, they don't have, the tribe does not have taxing authority. The one exception I've been told about, and I should have told you this at the beginning, I'm not an Indian lawyer, I'm a bank lawyer. My clients were J.P. Morgan and Wells Fargo, so this is all new to me. I only know about Indian law to the extent I've been told about it or read about it. But in any event, as to the taxing authority, the one exception was, I guess they do have some ability to assess liquor taxes. There's a case that was decided last year by the United States Supreme Court. There's a little village called Pender, Nebraska, where the makeup of the community was, I think it's 99.7 or 97.9% non-Indian. And the tribe said, well, this little town was actually within a reservation, and they wanted to assert liquor licensing fees, and it went all the way to the United States Supreme Court, and the Supreme Court said, yeah, it's a reservation. This 1882 statute never undid it, so they can assess these taxes. But that's the only one I'm aware of. So not only would bars and restaurants in Pender, Nebraska have to pay the Nebraska state licensing fees and so forth, but they'd have to pay, now they got to pay the tribe. So the point is, all this stuff is very real. And another question that comes up is, well, it's been 161 years, 162 years now, lapse of time, because we all know about statutes of limitation. That's not the case here. Time-based offenses don't really come into play until, in a very limited role at the very end of things. It may be that there could be some value to the fact, from our side, to the fact that the tribe hasn't exercised certain rights. Anyway, ultimately, I'll give you finishing up into the current status of the case, really since last year. It's all been about discovery. The evidence in this case is not only going to be the written word, but it's going to be expert testimony. There are people out there, I guess they're called ethno-historians, and they study this stuff. They're PhDs at universities and other places, and they study the language of the treaty, the language of the time, the correspondence from Indian agents to the federal government, congressional records, and so forth, and they will testify before Judge Paul Maloney as to what their reading of this statutory language and what the reading of the treaty language was. Obviously, the tribe didn't just file this suit and then go out and get an expert. They've been working on this for years. Our lawyers will tell you they've been working on it for 20 years. So they got all their ducks in a row, decided they had a case, and went ahead and filed it.
Who's this expert? Is he like a consultant?
Yeah, he'd be somebody, and my guess, I'm sure he's got a PhD and some sort of anthropologic background and studying this stuff. I have his name. I'm not even sure quite where he's from, but he's got a big research team in Washington, D.C., and these guys are pricey, which ultimately gets to one of the reasons we're getting the word out, and I'll get into costs in a second, but they're doing all this research. The tribe has been filing all sorts of motions. This winter, they apparently filed one asking our side to list by parcel each parcel in this 337 square miles that we contended was not subject to the reservation. We're going, first of all, it's almost impossible, and secondly, it shifts the burden of proof. It's not us to prove that they're exempt, it's up to them to prove there's a reservation. Fortunately, the judge bought off on that and said you don't have to do that. But they're being very aggressive. I will tell you that these cases are going on all around the country. Let's see, what else can I cover here? Ultimately, as you'll see on page 3, this case, the tribe's public position, and it was, somebody sent me a clip from Channel 407 this winter. It's been in the Detroit paper, it's been in the local papers just a little bit, but their public face on this, their talking points is this is about Indian child welfare, and it's about historic grave protection and so forth. That's not what this case is about. That's a nice spin on it, but just like almost any litigation, eventually it's about power and money, and that's where this is going to go at some point. So they can spin it any way they want, but if you try to sit down and talk to them and say, well, gee, if it's just about preservation of grave sites and it's just about child welfare, we can work something out. No, not so fast. Maybe let's talk about some more things too. So it just gives you a little feel about what could be involved here. So I would encourage you to take a look at this. You're welcome to share it. I do want to talk to you about the Protection of Rights Alliance. the part of the big thing that we've been doing about getting the word out is ultimately we got to raise some money for this, and so.
Can I interrupt just a second? What's the timeline right now? Where are they at?
They
It
are-
looks like it's extended out a bit more now.
Yeah, they are in, they're in pretrial discovery. The experts are working on their reports. I should go back on the bottom of the first page. The case management order that was entered just about a year ago, I understand it's been modified, but I haven't seen it as to how it worked out. I'll start by showing at the bottom of page 1, and this as much as anything drives home the point about how serious this is. You can't get 25 days of federal court trial time for a garbage matter. I mean, you know how backed up the courts are, and he's now estimating 25 days of trial time for phase 1. You can do 3 murder trials in that time. So the court obviously is taking this very seriously too.
So there's no idea when the trial date's gonna be?
No, right now a guesstimate would be October of 18, probably.
Who makes that determination? The judge?
Well, and the parties will reach an agreement. It depends. Discovery's been extended, as you can see from the top of page 2. Initial expert reports were originally due next week. That has been extended, and what happens then, the experts exchange reports, and then the other side rebuts those. So those rebuttal reports were due September of this year. Expert depositions were to begin in September of this year and completed by next April. Well, that and then final dispositive motions, pretrial motions, were due next July of 18. So that was an indication he was probably headed towards a fall of 18 trial date. These dates have been pushed, but I don't know how far they've been pushed, whether they were pushed 60 days or 90 days, but it's going to be out there. It wouldn't shock me if this trial started in 19 in the absence of a settlement. I should tell you a little bit, too, about the Plaintiffs' Council. Plaintiffs' Council is out of St. Paul, Minnesota. They have these cases. By getting the declaration of a reservation, there is a bunch of federal money available to all these tribes, so that's one of the incentives. And it does give them power. I know that Indians, the tribe here, and you can go to their website, Little Traverse Bay Band of Odawa Indians. They posted on there is they have their own Environmental Protection Act, which would then, to the extent developers are doing things on this within these reservations, they would have to comply with the Indians' version of the Clean Water Act. Now, apparently, it tracks a lot, but not completely, because I'm told by our lawyers that it purports to regulate water in the ground, which I guess the federal government doesn't. I'm also told, I think we all know that the states, under the federal EPA, the states have the ability to implement those. Obviously, the Flint water crisis brought it to the fore that the state regulators kind of blew things there. But the tribe actually, if they get trained, they can take on the authority of the estate to become the local EPA qualifier on reservation property. So now, if you're in the construction business up here, you might be held to tribal standards, whatever those may be.
Is any of the land up here considered reservations for the Odawa now? Do they have any?
Yeah, I don't
full
think any.
reservation?
Our argument is there's no reservation here. They have land here, and they have the casino land, and that's federally regulated. But I don't think it's official reservation status. I'm not aware of anything up here that's officially reservation. But to the extent they own land, they have the ability to put it in trust through the Department of Interior, and that it becomes subject to special treatment, but there is no, quote, reservation that we're acknowledging at this point. Saginaw, Chippewa had a deal down in Mount Pleasant a couple years ago where the private parties did not intervene, and eventually Governor Granholm, over the objection of the Attorney General, settled the case, and they worked out some of these police agreements and zoning agreements and so forth. But because there were no private parties at the table, the government said, okay, let's work this out, and so they did somehow. And Hogan Adams was part of that one too. There's lawyers, so this isn't their first rodeo in Michigan either. What I do know is that the federal court has asked each side, nobody wants to mediate this case, but the federal court here, in our case, basically said, well, we want everybody to name mediators, and the tribe immediately went to somebody that was involved in that case.
Okay.
And said, that'd be a qualified mediator. They also went to somebody in New York or D.C. who teaches basically an Indian advocate law, and you think, well, I probably don't want him for a mediator either, you know. So in any event, but I don't think there's any precedential law out of that one. But again, Governor Granholm is basically said we're going to settle this thing, and nobody really wanted to do it, which again emphasizes the importance of having the private parties, in our case, at the table. They're going to have to deal with us too. In terms